public comment. We have two hands raised on Zoom. Anyone in the room who'd like to speak, come up to the podium. Jacob Hollers, I will ask you to unmute.
Good morning, commissioners. My name is Jacob Hollers. I am the outside counsel for the Will-O-Wisp Metropolitan District in the 106 litigation that we recently got a judgment on last week. The district wanted to make a few comments. Kimberly Merriman, the president for the district, is also on, as well as Katie James, general counsel for the district. I just want to make a few quick points. As the board is aware, on Thursday, the Park County District Court ruled in favor of my client and issued an order reversing the Board of County Commissioners' approval of aSkag's PUD zoning for its waste transfer station and enjoined aSkag from continuing to operate. Despite this judgment, aSkag continues to this day to operate as if nothing happened. The district has numerous videos showing this is still occurring. The district, in fact, recently filed this morning a response to aSkag's motion to suspend the injunction, submitting photos and videos to that effect. Because the Colorado Court's e-filing system doesn't allow videos, those have not been uploaded to the system, but are being mailed out on a thumb drive to the court and to counsel for the parties. We expect that the court will be denying aSkag's motion and will likely be quite upset at aSkag for flouting its judgment and injunction. The district is evaluating its options as to aSkag, including a potential motion for contempt citation. But even if this injunction were to be lifted, and again, we expect it won't be, Park County independently has a duty to stop aSkag's illegal operation. Again, the court reversed the Board of County Commissioners, meaning that the zoning on aSkag's land reverted back to, I believe, residential, and so its heavy industrial use is now unlawful. Under Article 2 of the land use regulations in Park County can and should be issuing cease and desist orders and enforcing those cease and desist orders through civil and criminal penalties and other remedies. If the county doesn't do this, the district is prepared to take appropriate action to force it to, such as by seeking a writ of mandamus. And again, I understand that the board is going to consider whether to join aSkag's pending appeal that it filed on Friday. It's the district's position that it would be improper for the county to join that appeal and really back up just one resident's application and position. Rather, the district takes the position that the county ought to simply be taking no position on the appeal and let aSkag advocate for itself, unlike what happened in the district court. An appeal could be quite expensive to the county. That money could be better spent elsewhere. I don't know the rates that the county's outside counsel has been charging, but it's not unreasonable to assume that attorney's fees on appeal will be well into the 5 figures, if not more. I appreciate your time and consideration. I understand you have an executive session to decide what to do, but the district would ask that the board keep in mind all of the district's comments here today, mine included, as well as Ms. Merriman and Ms. James. Thank you.
I appreciate that. Your time is up.
All right. Next one, Kimberly Merriman, I will ask you to unmute.
Hi, commissioners, and good morning. Thank you so much. I am calling in not only as president of Will-O-Wisp Metropolitan District, but also as a concerned citizen. I also had emailed you each individually last week when the ruling came out on Friday late afternoon. I just like to say we've been down this road for a lot of things regarding this PUD, and to really enforce the action that the court has ruled on with the injunction, and to also not participate in the appeal. I think it's very important that, as Jacob, as our attorney, reiterated, that aSkag proceeds with the appeal on its own, and that the BOCC, the commissioners, and the county take a neutral position and stay out of that appeal. Additionally, as we know, there's been no follow-up from when the PUD was approved regarding operational plans, engineering plans. I'm not even sure if there's been site visits. We know last summer there was a septic spill that not only came into the district lands, but into 2 residential homes within Will-O-Wisp. So it's really, you know, at the behest of everyone, and just from the district's standpoint, we really view that this operation is dangerous and concerning to not only us as a neighboring district, but all the neighbors that surround it on Juan Crest and everywhere else. So just really from my standpoint, to really think, hard and deep. I know you have the executive session, and there's been a lot of information that's come out. We got the CDPHE letter in August that showed all the deficiencies. I think it had been very, very helpful when the previous county manager and director of operations could have mentioned that, and Mike Smith, that he had reached out to CDPHE to get that letter to see those deficiencies in time before you made the ruling. But now we have a lot of that information kind of in hindsight. And because of the ruling, it does revert back to residential, and he is still operating, right? I live in the area. I've seen the trucks myself. We have videos, we have photos, lots of people, and not just myself, lots of different people have taken documentation that he has been continuing moving forward with his business and ignoring the injunction from the court that was issued Thursday morning. Thank you so much.
Thank you, ma'am. Appreciate your comments.
All right, next up is Kay James. I will ask you to unmute, and if you'll give us your full name, please.
Good morning, Commissioners. This is Katie James. I'm General District Legal Counsel for Willow-Wisp Metropolitan District. I'm just going to tag on a little bit to what Jacob, our litigation counsel, and our president have already said today. Not to be repetitive, but just to make a few kind of slightly distinct points. The district just wanted to reiterate that, aSkag is one person / one family / one entity of your county residents and taxpayers. And as the Board of County Commissioners already knows, or at least two of you were present through the hearings through the previous application process, so you would know, there were dozens of other taxpayers within the district and other neighborhoods around the district that opposed this application from the start. As those residents and taxpayers stated in multiple hearings during the application process, they want to be recognized as well. And I think as Ms. Merriman brought up, there's a lot of hindsight in this situation. The court has ruled that this was the incorrect process to undertake by the county. I think, at least one commissioner at the actual vote, felt the same way, if I recall from the hearing. And the district would really just like to point out that if the county can recognize errors that it made and support the opposing residents by complying with the court's order and enforcing the county's own zoning regulations, that would go a long way to this chunk of residents of the county. aSkag currently is residential zoning and is operating illegally, and the district would just reiterate that we would wish the county to enforce its own zoning resolution and issue a cease and desist and follow through with that. I think it's important. The district is a local government, the county is a government, and the district continues to maintain that this project is overall a threat to its water supply. That was evidenced by the spill that happened last summer, just as exactly as everyone was concerned about during the process would occur without proper oversight or at this location in general. That did occur, and the district still concerned about that threat to its water supply and the quality of life for its residents, and really just wants to reiterate that it seeks the county's support for the district as another local government to proceed in compliance with the court order and assist, the multitude of taxpayers that have been sort of sounding this horn since the beginning. Thank you.
Thank you, ma'am. We appreciate it.
All right, next up, Stan, if you'll give us your full name, I'll ask you to unmute.
Hi, my name is Stan Bates. Do you hear me?
Yes.
Yes, I represent Juan Crest HOA as well as the Park County Neighborhoods Alliance with Tim Jones. We concur with everything that's been said this morning and align with the legal position with this situation. We've been on this road the whole time. It's been a very difficult road for the community. We have stayed persistent, and we have gone through many different stages of protesting the original permitting of the building on the hill that was not permitted properly, as well as the road. And I don't need to go through all of those details because we've all been along that road. But we as a community beg you, we ask you in full confidence that you will do your job, is to, at this point, right the ship, make it right with the community, and enforce the ruling from the judge. She's obviously taken a lot of time to review this, and she hasn't taken all of the different issues, but the ones that she has focused on are clearly in the wrong. So we ask you to shut down the facility, to red tag the facility, to make sure that there's nothing going up that road and basically shut it down, because that's what the judge has determined to be the lawful thing to do at this point. So I appreciate your time. It's been a long road. I appreciate your patience with the community as we've tried to voice our opinions that may have been counter to some other opinions, but we feel that we are now heard and we want it executed in what the judge has said. So thank you very much. One final thing is we would like the land cleaned up. So that's the final ask, is that he's done a mess up there and we would like that land clean. Thank you.
Thank you, sir. Executive session pursuant to CRS section 24-6-402, paren 4, paren B. I would like to make a comment. Oh, we just need to move into session.
We'll go into session. We do that after.
I understand that, but I have a specific calling to announce to people. Okay. Sorry about this. So I just wanted to be on record that I personally know Adam Shirley had friends with him, but also had businesses with him. I want the public to know that in no way will this hinder my decisions moving forward with this situation. And I am stating to the public that it will not affect my decision making or speaking either way. Okay, thank you for that. Appreciate that comment. Any furthers? Call the question. Those in favor vote by saying aye.
Aye.
Aye. Opposed, same sign. Okay, so at 11:28, folks, we are going to go off to the side and do our executive session with our county attorney. We will return. We don't know. Okay, thank you, Ms. Susan. It is now 12:19 p.m. That note here on my paperwork. And the executive session has been completed. Participants in the executive session were County Attorney Aaron Smith, Commissioner Dave Whistle, Commissioner Amy Mitchell, Commissioner Jason Kimmer. The participants in the executive session were as I so stated. The next agenda item is to discuss the counsel and legal information received from counsel. Madam County Attorney, would you like to help us?
Yes. So just clarification, what's on your agenda is to consider action, if any, related to pending litigation. So that is what's on your agenda. And you've had a request, two requests. Two requests are before the board by virtue of the attorneys in the waste transfer case litigation. On the one hand, the attorney who represents the defendant in that case has advised that he has filed a notice of appeal and has asked the county if the county would join in that appeal. I would just point out to the board that there, are several things with regard to the district court orders that I don't necessarily agree with. I would just point out that at this point, the county commissioners made a decision to defend that action that it took with regard to the waste transfer case. It made I think a good effort to defend that case in the 106 hearing, and the district court disagreed. So at this point, in order to take up an appeal, the board would have to expend money. And I think that is a fairly compelling issue in a budget year like you've got, the expenditure of money for an appeal. And I would just let the board discuss the money aspects of taking up that appeal. Be happy to answer any questions.
Okay, any questions for our county council?
No questions. Thank you for framing that question in the first issue that is before us. Boy, we've got a really tough budget year. And we are continuing to look for savings at the county level because we are operating on a less than desired reserve. It gives me great pause to think about having to spend additional monies.
So I would agree with that. So some of my thoughts are, you know, we really don't have any obligation, from my understanding, from the courts. And I believe that the financial responsibilities on the county utilizing that legal device would be pretty difficult on us at this time.
Let me just say, Ms. Davis, just for my contributions to this discussion, when we go back and look at the order of the court, they did not remand this back to the Board of County Commissioners. The court has assumed the authority and responsibility, and through the requests has more enforcement power than I think we do as a county. And again, it would take us outgo of funds in order to do that. I think this is one of those situations where the process has worked to the, not the desired outcome of the applicant, but to the proponents and the petitioners that this ruling assists. And so with that, I don't know what the county can do in talking with council that would be any more beneficial than what the neighborhood associations and alliances could do with the position that the court has taken. So with that, it really does come down to a resource issue in my mind.
And I thank you for that, Commissioner, because that was the second question. You're exactly right. The second question that you've been asked is to take up some sort of separate enforcement action. So your thoughts were very appropriate with regard to that request to take up some enforcement action. So again, there are two requests, and I think, you know, you could just take them separately after you've had your discussion, and I can, you know, remind you what the two requests are. One is to join in the appeal, and then on the flip side, one is to take some sort of separate enforcement action.
Thank you, ma'am. That's helpful and clarifying, I believe.
So I you know, in my opinion, I believe at this time, just kind of under some of my opinions is I believe that no action should be taken on joining the appeal at this time. It's just fiduciary irresponsible, in my opinion.
Yeah.
Okay.
I agree with Commissioner Gemmer. We are looking to save money, not to expend additional money. And we are operating the county as frugally as we can, honoring our staff first and foremost. And I think that it would be the wrong, I think that my decision is to not join in the appeal, mainly on financial concerns.
My position is similar. I think when we look at the totality of this incident, this issue, and we look at the potential costs for the appeal, we are in no position to expend monies that we are not accounting for or have planned for. And for that, I would not be in any position to join in any litigation on either side.
So may I make a motion that we do not join the appeal? Is that a proper motion, or Aaron, would you like to frame it better?
No, that'd be that's fine. Thank you.
Okay.
Okay, that's a proper motion.
I'll second that.
Okay, further discussion. So basically the question before us is we're not going to join an appeal on either side.
I agree.
It's pretty clear.
That's clear.
Okay,
Okay.
so is that the motion then, to do nothing further? You're not going to join the appeal, and you're including in that you're not going to take up any separate enforcement action?
Well, I thought the first question would be to join an appeal or not, and then we
Okay,
needed to
thank you.
perhaps discuss in any enforcement.
I think that would
So-
be, that'd be best. Thank you so much for that.
Thank you.
clarity.
You're
So I
welcome.
think the motion I put out was that I move that we do not join the appeal.
That's the motion I heard, and that was what Mr. Kimmer seconded.
That's correct.
Okay, any further discussion? Being done, we'll call a question. The question will be to not join in any appeal on either side on this case. Those in favor, vote by saying aye.
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 Opposed, same sign. That motion carries 3-0. Now, the other ask for us was to enjoin in some way, shape, or form that we may not have the prohibited use for the court, per the court, for the activities going on the aforementioned aSkag property.
Yeah, I think the request is to take up some county enforcement action. And so I think that's the question. Are you going to take up enforcement action on your own? Or does the court's injunction order, which is superior to what the county might do, does that suffice for serving the purpose of the activity, being subject to the court's injunction order?
If we look at it from the court's perspective, they have issued that order and basically the conditions to cease and desist under. They have the judge already primed for this in the lawsuit. We would have to go through a completely different enforcement order that I don't think would be as effective as district court is right now.
Right, and the decision by the judge did not request the county take any action. It basically just reversed the decision that was made by the BOCC. And so we were not requested by the court to take any further action. And if we did decide to take further action, it would be expending money that we don't have. And so that's my logic that I don't think we need to take any further action because the court's already made their ruling and it will go forth through that structure through the court.
So I would agree with that. So looking into this, I believe that the plaintiff and the court itself has a way better reach utilizing the court to involve themselves in this. I believe that the costs of the county getting involved with this and then the legal issues that come from that may be pretty gruesome when there's already a great method for the plaintiff. I believe the county should not issue any cease and desist and allow the court to do its job.
You want to put that in the form of a motion?
Sure. I move that Park County not take any further action with regard to the court decision and that we take no action on the second request. Is that okay, Erin?
Yes, I think you would, your motion should be that you are not going to take up separate enforcement action at this time.
I move that we not take any enforcement action at this time.
Okay, well, accept that as a proper motion.
I'll second that.
Okay, any further discussion? We've enumerated, I think, our reasons because there are other devices besides the county in place right now for any enforcement.
Correct.
Yeah, and I think the decision that the court handed down really directed any further action to the court, not to the county. So I think that's the right decision.
All right, well, let's call the question. Those in favor, vote by saying aye. Aye.
Aye.
Opposed? Same sign. That motion carries 3-0. That is, I believe it concludes what we needed to do, Madam Legal, for the.
Yes, it does. Thank you.